You should never guess in your pretrial deposition in a personal injury case. Hi, I'm Guy DeMartino. I am a Northwest Indiana personal injury lawyer, and today I would like to explain to you why. So first, let's backtrack just a moment. A deposition is a statement under oath. This is a time when the other lawyer or lawyers are going to be able to ask you questions under oath, and everything is going to be taken down by a court reporter word for word, and you might also be videoed. So this is what the whole purpose of a deposition is. The purpose of a deposition is to lock in your testimony. And they lock the testimony in for a number of reasons. Number one, to see what kind of historian you are, to see how you behave under pressure, to see if you're able to articulate what happened in the accident, articulate what your injuries are, how it's impacted your life. Number two, they go ahead and they lock down your testimony, because if you should say something at trial that's different than what they said in your deposition, then you can be impeached. For instance, in the deposition, you say you have a green light. In trial, you say it's a red light. They pull it out and they say, I remember we were together. It was a period of time ago. You had your lawyer, you were under oath, you said that the traffic light was blah, blah, blah. Now you're saying the traffic light is blah, blah, blah. Why is there an inconsistency? Were you lying then? Were you lying now? However the lawyer wants to go ahead and do it. So, when you give a deposition, and when you answer the questions, you really want to answer it based on personal knowledge, based on information that you have, and you shouldn't guess. The only time you may want to guess, for lack of a better word, when we say guess, make a reasonable determination, is it's okay to do so at times as long as you qualify your answer. For instance, were you ever involved in another car accident? You answer yes. When? You think, the years go by, you don't really remember. The way that you can go ahead and answer the question, even though it might be considered a guess, is this way. I don't really remember the exact date of the other accident. I believe it was in the early 2000s, or I believe it was around 2005. Don't hold me to it, but I really believe it was that. You see, you qualified your answer. So then, should your testimony change at a later date, or should there be a record that shows up from the accident and it shows that the accident was in 2015 instead of 2005, they can't say, aha, you were lying to me. What were you trying to hide? You've already given saying, I don't really remember, but I think. I believe it was at this time. So they can't get you in front of a judge or a jury and say, well, were you lying then? Or are you lying now? You see, these cases are based 100% on your credibility if you are the person who's bringing the claim for the accident. What defense lawyers try to do, and the way that I like to explain it, is that when you go into court, you're a block of ice. And what they try to do during the days in court is chip away at that ice block. Lack of credibility here, mistaken testimony here, not quite accurate between the doctor's records and what you testified. So they keep on chipping away your credibility. And then when they come to a closing argument, they say, nice person, but maybe they're overstepping. What about, I asked them so-and-so, they said so-and-so. So what they do is they try to chip away at credibility because you are the one that is bringing the claim. So one of the ways to protect you is to never guess in your pretrial deposition testimony. If you have any questions, you can always reach out to me. I am Guy DeMartino, meeting you at the intersection of law and medicine. Have a great day.